the member of the bar who's at question here today. I just have some brief points because I only have a minute. I still stand by the 39% conviction rate, and the woman I ran against, nice lady, she was the chief deputy under that. I had an expert testify, former chief of computing. When it comes to this religion issue, publicly I stated, I don't know my opponent's religion and I don't care. Some other people said some stuff, I didn't. Okay, just to clarify those facts. When I joined the Army in 1995, I took an oath to defend the Constitution of the United States. Now the Florida bar says the Constitution doesn't apply to Florida attorneys. That's the way I see it. That's the way it should be, and that's the way I'm asking this court to see it. Effectively, the Florida bar is saying the First Amendment rights don't apply to Florida attorneys in partisan political elections. Yes, we're talking about quasi-judicial. This was a partisan race. I lost in a Republican primary. I wasn't running for judge. I'm asking the court today, you justices, respectfully, to stand up for free political speech. Remember first-year law, strict scrutiny? Okay, everything I said I believed in, and I backed up with facts. Okay, we even brought many witnesses to show what I said was true, many articles to show what I said was true. I believe what I said was true. I understand that the referee didn't, but the referee had a conflict of interest, respectfully, that she admitted to. Okay, I'm asking the Florida Supreme Court to support and defend the Constitution of the United States. I thank you for your time. I spoke very fast. I'm a little nervous being up here, forgive me, but it's a long record, it's a long brief. I would ask you all to look at the facts of the case, because we actually put on more evidence at the referee hearing than the bar did. We brought in witnesses, we brought in articles. I believe if you look at all the facts, if every justice looks at all the facts, you should ask what we're doing. And I thank you for your time.
Could you just give us the 30-second version of the 39 of the your argument on the conviction rate thing?
Yes, witness William Smith, who testified at the referee's hearing, who's the former chief of data and computing for the state attorney's office for the 20th Circuit, he got it together, and we looked at all the arrests versus all the adjudications of guilt in the circuit. Now, there's a big debate about do withholds count, do diversions count, but we said over several past years, like I said, I went to an expert first on this, sir. Okay, I just didn't make it up. And it's a big debate, but that's what campaigns are about, sir. So, I'm sorry. I don't mean to be disrespectful. We looked at all the convictions versus all the adjudications of guilt, and that's where we came for the past 2 or 3 years or 4 years past. And I said that my opponent was the chief.
For the office.
Yes.
For the office. And so basically your theory is that because of her high position in the office,
exactly,
that, you know, she's responsible for the activities of the office.
That's what it said on her website. That as chief deputy, she effectively was the chief executive officer. And when we were campaigning, and I don't blame her, she was bragging about how she ran the office all the time. We went to hundreds of forums. It's a 5-county area. So I said, yes, you have a 39% conviction rate. And I did it in good faith, sir. And I believe it, and I believe it today. And I went to an expert. We actually pulled those numbers from the Florida administrative courts, and we went to a couple counties that provided it as well. The county numbers were very similar when you look at adjudications of guilt over, I think it was a 4-year period, I forget. It's in the testimony of Mr. William Smith. But we came up with the 39%, and yes, I stated it. And we had big debates about whether it was 39% or 85%, but this was a debate that was done in good faith. It was not a blatant lie. I didn't blatantly lie about anything. So there were some independent groups that did some stuff that I was not privy to. I don't think I should have to take ownership for those. Okay. We even objected having those put in evidence. But I'm asking this court, respectfully, to please stand up for the First Amendment. Thank you.
Mr. Crowley said, I don't know my opponent's religion and I don't care. One of his mailers that he approved said, Fox refuses to disavow her direct ties to the PLO terrorist organization and she won't answer questions about Sharia law. I don't see any reasonable reading of that doesn't put her religion at issue.
What does that have to do, though, with qualifications and integrity?
It has to do with her integrity because he was implying that she was interested in attaining higher office to enforce Sharia law. That's why he shared the American Thinker article that said that.
I'm not sure. I mean, part of the problem is that this rule is obviously, the core part of what this rule is getting at is not really, I mean, obviously it addresses candidates, but I mean, the main part of this function, the rule is not really, it's not written to govern campaigns. I'm not saying that it doesn't apply, but we're talking about applying it in a setting that's sort of at the periphery of what it's for, and it's written to cover factual statements. We obviously know that in campaigns, I mean, most of what you're talking about is either debatable fact or opinions or mixed or whatever, and then it's even narrower than that because it goes to qualifications or integrity. I don't really know. It seems like if you read integrity the way you do, that would sort of just swallow up. It's really not a limiting word.
Well, first off, I don't believe that this case really does fall on the periphery of the rule if the rule specifically applies to candidates for legal office, and then the comment specifies further that that applies to prosecuting attorney. That seems to be wholly established by the plain language of the rule.
I mean, you don't think that the main point of this rule is to address things that are going on in the context of litigation? You know, the judge is this or that, the jurors are this or that, my opponent, you know, my opposing counsel is whatever. I mean, we don't need to get into a debate about that, but it just seems like you're not. There are things. I mean, this is a hard case, just in general, but it seems like the bar's view of it makes it even harder by not sort of reading the words more naturally than, I mean, I understand prosecutors sort of expand the, you know, prosecutors push the boundaries of the words as far as they'll go, but it seems like there are more sort of naturally sort of limiting ways to read some of this stuff that would take some of this stuff just off the table completely.
The way the bar has interpreted this rule is to apply it equally. So if you have, we cited DuPont, we cited Jacobs, both of them were 91-day suspensions, both of them involve similar conduct, and if the main factual distinction is, yeah, but that was against judges, this one was against a candidate for state attorney, that's just not a distinction that's referenced in the rule. When this court says objective factual basis test in Ray, it was applying it to the whole of 4-8.2a. So the bar just treated it the same as it would if he had disparaged a judge under those exact same circumstances, recognizing he's never had prior discipline, but he refused to acknowledge wrongdoing, and this involved dishonest conduct. We are seeking the minimum amount of time you could have for rehabilitative suspension, which is 91 days.
And having heard what he said about the 39% thing, what's your response to that?
The 39% statistic is false, and
could you just specifically respond to what he said?
Sure. I'll address what he said. What he did was he took total arrests in Lee County for calendar year 2016, and he compared them to total convictions in that same county. That's not going to establish Amira Fox's conviction rate. Those aren't all the cases she handled. It presumes that...
Well, but you're ignoring what he said about her position in the office, and it is not an unreasonable thing to say if you claim responsibility for running an office, that you get the blame for things that aren't going well in the office. I'm mystified by the blindness to that, quite candidly.
The blindness to it, it's not blindness. What it is he took total arrest. So he's presuming that every arrest should result in conviction. That's what you mean. That's what it means when you take that number and you divide it by convictions and say she dropped the ball in these other 61% of cases. There could be a million reasons that there wasn't a conviction, and it doesn't have to do with the office failing.
Okay, we're talking about different things now. You're talking about one thing there, but you're talking about this not being her conviction rate, right?
Right.
And so you think that because it's not her conviction rate, then that it's some more global number, and we can argue about the accuracy of that. Okay, that's a separate issue. But you think it is somehow he's violated his duty when he attributes the performance of the office to her because of her position in the office.
I think that's one aspect of it, and the other aspect is...
I have real trouble understanding that in the context of a political campaign where... that just flies in the face of a lot of a tradition of the way campaigns and the First Amendment works in this country.
I understand the concern, but I would also just point out that it's not even a conviction rate that would apply to the office generally. It was a false figure, even if you're viewing it in that lens and then attributing it to her. Either way, it was false.
What should the numerator be? Number of cases indicted? Number of informations filed?
It's hard for me to really just establish how he would calculate that figure, because very frankly,
You have to, though. I mean, if you're going to accuse someone of making a false fact, there's the issue of what's the universe? Is it just her personally, or there's the office? But then now you're kind of making a technical point about how we're supposed to, like, what would the listener understand conviction rate to mean? And I would think that if you're going to prosecute someone for making a false factual statement, there would have to be some sort of understanding as to what is the quote unquote fact that we're talking. What is the factual sort of measure of this, and is this false in relation to that standard, right?
Well, what I think the issue is he's calling her corrupt, and he's offering that as an objective factual basis to say she is corrupt. And the case law in Ray is...
Now you're mixing other stuff in, and I'm sorry, I didn't mean to talk
That's the same
over you.
point.
No, I don't think I am mixing anything in when he says that's a reason she's corrupt, because under Ray it says when you make a disparaging statement, the burden, we just need to show it was disparaging.
Now you're saying disparaging statement. I mean, this is false. This rule applies to false statements about people's qualifications or integrity. So I don't even know corrupt. I'm not even, that to me, I don't even know if that's what does that even mean to call that a factual statement?
He even put in his brief that it means impairment of integrity. So I think that does apply
factual?
to the factual basis with a 39% rate. That's the part that he is offering as a factual basis to say she is corrupt. That wasn't just a defense in the bar proceeding. He was saying that throughout his campaign as one of the many reasons that she was corrupt or that she orchestrated his arrest. All these different bases that didn't have any basis in fact. And very frankly, the burden was on him to establish that he had an objective factual basis. The bar just had to show that he made those statements that were questioning her integrity or her qualifications, and then he had to establish the objective factual basis. That's the burden shifting standard under Ray.
Okay. It seems like you should have to establish that something's false first before someone then has to defend themselves.
This test under Ray was that we present evidence that the statement was made and it questioned her qualifications or integrity.
So you don't have to prove that it's false.
He has to offer the objective factual basis. That's
okay.
The test.
We probably need to look at that.
All right. With that, I see I'm way over my time. So thank you, Your Honor.
Thank you.